final matter to come before us today is Serra versus Guitar Center Inc., DBA GuitarCenter.com, et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping the clock and I can keep you apprised of the passage of time. If you would hold off starting for just one moment, though, we're having technological difficulties up here, and we're trying to get prepared so that we can pay full attention to your argument. The court's read the briefs. We're ready to proceed when you are.
Good afternoon, Your Honors. May it please the Court, I'm Lorain Serra, the appellant in this case and the plaintiff in the trial court below. I appeared today before the court pro se, and I'd like to reserve 5 minutes for rebuttal. Your Honors, the Court of Common Pleas erred when it permitted Guitar Center to file an answer in this case because the answer was filed out of time. Guitar Center did file a motion seeking an extension of time, but in violation of Rule 6 of the Rules of Civil Procedure, it failed to establish any cause whatsoever for the extension of time. Rule 6 of the statewide Rules of Civil Procedure provides that for cause shown, an extension of time may be obtained. The local rules of the Court of Common Pleas, Rule 9.3, requires a higher standard, even good cause. Here, the defendant's motion simply said, we need more time to respond to the plaintiff's complaint. That comes far short of establishing any sort of cause whatsoever. And without establishing that cause, it is an abuse of discretion for the Court of Common Pleas to grant an extension of time. That is not a decision that is based on logic, without bias or passion. It is completely arbitrary and capricious. Every single element required by the rule has to be satisfied. And here, simply looking at the one-page motion consisting of a single sentence requesting additional time makes it perfectly clear that the requirements of Rule 6 were not met. Because there was not a valid extension of time obtained, that means that the defendant's answer was filed late, past the 28 days required by the rules. Right? Late answers can only be filed upon motion and a showing of excusable neglect. When you look at the cases that define excusable neglect, you'll see that there are situations where someone either completely lacked notice, or in one case, there was a situation where an attorney's assistant misfiled a complaint and it was in another client's file and not discovered until after the time for answering. Here, Guitar Center had engaged counsel a full 3 weeks before the answer date. Their counsel was engaged in settlement discussions with me. They knew what their answer date was, and they chose instead to file a motion. Right? Having filed the motion, they have to make sure that they comply with all of the requirements. Right? Because they didn't, right, this answer was filed out of time. They cannot show excusable neglect for filing a late answer. That means that their answer is a nullity. Because the answer is a nullity, it needs to be treated as non-existent, and that leads to the conclusion that under Rule 55, I'm entitled to a judgment by default. The Court of Common Pleas should have entered that judgment by default. If we get past that issue, Your Honors, right, now we're dealing with the competing summary judgment motions. Guitar Center filed a motion for summary judgment asking the court to find that I had named the wrong party, Guitar Center Inc., as the defendant in the case. In support of its summary judgment motion, it filed a single affidavit by Mr. Timothy Martin, their chief financial officer. In that affidavit, Mr. Martin stated that the entity I was suing, Guitar Center Inc., was not engaged in any online business whatsoever, and that it was a subsidiary, Guitar Center Stores Inc., that was actually engaged in this business. In opposition, I submitted evidence of my own, right? That evidence consisted of documents from the actual sales transactions themselves that were sent to me from Guitar Center Inc. that have Guitar Center Inc. printed on them. They have logos and trademarks owned by Guitar Center Inc. on them. Right? The website that the sales transactions occurred over, guitarcenter.com, is reachable by typing guitarcenter.com into your web browser, and that domain name that takes you to their website is registered to Guitar Center Inc. The technical and administrative contacts for that website are listed as Guitar Center Inc. employees.
What's the Secretary of State have?
The Secretary of State does not deal with registrations for domain names, Your
Well,
Honor.
it does for businesses, so the business itself will be registered with the Secretary of State.
That's correct. And to be clear, Your Honor, which business are you talking about? Guitar Center Inc.?
Either one.
Guitar Center Inc. is not registered to do business in the state of Ohio, right? It voluntarily surrendered its license to do business here. Guitar Center Stores Inc., I do not know the status of their registration. But one of the allegations in the complaint was based on the fact that Guitar Center Inc. was doing business within the state of Ohio without having a license to do so. So, you know, particularly with the issue of declarations, Your Honor, right? We have submitted for the purposes of this litigation on behalf of the defendant, Mr. Martin's affidavit, which says that Guitar Center is not doing business in the state of Ohio, right? And does not even do business online. When you look at Guitar Center's filings before the United States Patent and Trademark Office, right, they registered certain trademarks there, and under the Lanham Act, the federal trademark statute, they are required to provide verified statements under the pains and penalties of perjury of the laws of the United States that describe their trademarks and the scope of their use. And for at least two of their trademarks, guitarcenter.com and the Guitar Center logo, they filed declarations under the pains and penalties of perjury that state affirmatively that they are engaged in the online sales of guitars. This specifically contradicts Mr. Martin's affidavit statements. When you examine the website itself, copyrights in the website content are claimed by Guitar Center. In the terms of use, there's a statement that says the website is brought to you by guitarcenter.com, or Guitar Center Inc. And one of the key actors in these transactions, Mr. Daniel Smith, right, lists himself with the California Bar Association as an attorney employed by Guitar Center Inc. And the defendant, in a later filing, submitted an affidavit from Mr. Smith stating exactly the same thing, that he is an employee of Guitar Center Inc. Now, when interpreting all this evidence in the light most favorable to me, it's clear that at a minimum, there is a question of fact that would prohibit entry of summary judgment on the basis that I had named the wrong entity as a defendant.
Why didn't you join them?
Because, Your Honor, I had absolutely no evidence at that time to indicate that I was dealing with anybody but Guitar Center. The only time I learned of the existence of Guitar Center Stores Inc. was first in one statement in the answer to my complaint, in which there was an allegation that I may have had internet contact with Guitar Center's subsidiary, Guitar Center Stores Inc. And then when I saw Mr. Martin's affidavit attached to the defendant's summary judgment motion. So I opposed the summary judgment motion and cross-moved for summary judgment myself. In opposition, the defendant filed a second affidavit, and that was from the chief tax officer internally. She stated that Guitar Center Inc. had filed, paid no sales tax in the state of Ohio because it had no business operations here. They also submitted as an attachment a long tax document that appears to have been filed with the Ohio tax authorities for Guitar Center Stores, Inc., that document is completely redacted of almost all useful information. All the financial information is unreadable. And the 2 points that we can determine from that document are, first, it refers to a different entity. And the fact that a different entity was doing business in the state of Ohio is not probative of the question of who I was dealing with in my sales transactions, right? The second, this document is so heavily redacted that, any useful information, right, is being withheld, and there are really no fair conclusions that we can draw simply from that document. Looking at all of this evidence as a whole, even construing these 2 affidavits in the light most favorable to Guitar Center, it's clear that when you weigh 2 affidavits that are very narrow, very carefully crafted specifically for the purposes of litigation, against all of the transaction documents, other declarations made under the pains and penalties of perjury that are completely unconnected to any litigation purpose, and all of the other information that I submitted, reasonable minds can come only to the conclusion that I was dealing with Guitar Center and not some other entity, Guitar Center Stores, Inc., and summary judgment should have been entered in my favor.
And you've reached a little into your 5 minutes rebuttal, you can proceed or
I'll end it there, Your Honor. Thank you.
May it please the court, I'm Brian Chiketic, arguing on behalf of At-No Guitar Center Incorporated. Good afternoon, Your Honors. I'd first like to address the motion for extension of time. The parties agree that the appellate court should review this under abuse of discretion standard. In other words, the question is not whether there was an error of law or judgment, but whether the court's attitude was unreasonable, arbitrary, or unconscionable. There's no dispute that Guitar Center Incorporated's motion was filed a day before its answer was due to Mr. Serra's initial complaint, and therefore Rule 6b(1) applies. And that rule gives the court discretion to grant an extension of time for cause shown. And now there's a dispute over whether cause was shown or not. Mr. Serra today said that Guitar Center Incorporated failed to show any cause whatsoever, and that the only statement that was made in the motion was that we need more time. That's not correct. If you look at the text of the motion, there is clearly reason stated. It says that the motion is being filed, quote, for the reason that counsel for defendant requires additional time to respond appropriately to plaintiff's 23-count, 45-page complaint. Now that's a concise statement. It's a short statement. I'll grant you that. But the message is clear. This was a long complaint. There were a lot of charges that were being made, and Guitar Center's counsel required time to investigate that and file a proper answer. Mr. Serra opposed the motion, and he also moved for default judgment. The Court of Common Pleas, after considering all the briefing on this issue, granted the extension to Guitar Center Incorporated, quote, for good cause shown, end quote, and he denied Mr. Serra's motion for default judgment. Guitar Center Incorporated then filed an answer 4 days before the extended deadline that was set by the court. So once the court set a new deadline, and Guitar Center Inc. filed 4 days before, there was no late filing. So 6b(2) does not apply. There's no need to go to excusable neglect. Guitar Center Incorporated's answer was time to file. And now Mr. Serra is arguing presenting some of the same arguments that he presented to the lower court, and asking this court to substitute its judgments. That is not proper under abuse of discretion standard. The lower court found that there was good cause shown, and it would be extraordinary to unwind 2 years of procedural history based on a judgment that proceed on procedural grounds. I'd like to move on to the summary judgment motion. The trial court granted Guitar Center Incorporated's motion for summary judgment, and it is undisputed that Guitar Center Incorporated properly raised the issue of whether it was a proper party to this action. And Mr. Serra does not dispute that the burden shifted to him to raise a question of material fact. Earlier, Mr. Serra, I believe he properly conveyed what the affidavit, the Timothy Martin affidavit, the facts that were stated in it. And so it was his responsibility, his burden, to refute those key issues of fact. He could have done this in one of two ways. He either could have shown that Mr. Martin was wrong and that Guitar Center Incorporated actually operated the website or actually had transactions with Mr. Serra. Or he could have shown that Guitar Center Incorporated and Guitar Center Stores Incorporated were so intertwined that Guitar Center Incorporated had control over Guitar Center Stores.
I'm going to direct your attention to on the bottom of page 6 of the trial court's entry where it says, it's undisputed that a corporate parent may lend its property and resources to a subsidiary, and that does not mean it's automatically liable for the conduct. I'm gathering that that statement is related to the lending of perhaps a domain name or whatever else may have been apparent on the face of the website. Inherent in that statement, however, does that seem to you like a finding that that's what happened here? A finding of fact that that's what happened with the website?
That seems to me, Your Honor, as if they're looking at the evidence in a view most favorable to Mr. Serra. That looking at the evidence that he's presented, it shows there's some things they talk about. There's a copyright registration notice on some of the emails that shows that Guitar Center Incorporated owns some copyrightable materials. There are trademark registrations that shows that Guitar Center Incorporated owns these trademarks. The domain name registration shows that Guitar Center Incorporated owns this domain name. That's all that it shows. It doesn't show that Guitar Center Incorporated actually controlled the website or operated the website, or that it was engaged in e-commerce using this website. And in fact, when you take a look at all of the evidence that Mr. Serra presented in a light most favorable to him, the ownership of the IP, the employment of Daniel Smith as an attorney, and the various registrations and the terms of use, that shows that at best, Guitar Center Incorporated provided back office services to Guitar Center Incorporated, that it owned intellectual property that Guitar Center Stores used, and that it shared legal resources with Guitar Center Stores. None of this shows that Guitar Center Incorporated actually operated the website or was engaged in e-commerce.
How would you know that? How would you know any of that? Everything that he's presented sounds like the only entity that he had any engagement with was Guitar Center Incorporated.
There is public information out there, it's not of record, on Guitar Center Stores that he could.
Well, I can't consider anything that's not in the record.
I'm sorry, just to answer your question as to how he would have known, he could have done additional searching.
And is that what you argued to the trial court below?
No.
Okay.
But also.
What's in the record to demonstrate?
What's in the record, he was put on notice in Guitar Center Inc.'s answer, his initial answer, that he may have done business with Guitar Center Stores. And once Timothy Martin's affidavit was entered showing evidence that he possibly transacted business with Guitar Center Stores, at that point, certainly Mr. Serra could have joined Guitar Center Stores Incorporated.
Thank you.
And so the evidence, even taken most favorably to Mr. Serra, does not show that Guitar Center Incorporated had control of Guitar Center Stores or that it operated the website, merely that it owned assets and shared resources with Guitar Center Stores. I'm happy to field any further questions. That concludes my presentation. We ask that the lower court's orders be affirmed.
Thank Sarah, you have about 4 minutes and 20 words.
Thank you, Your Honor. Your Honor, with the issue of cause on the extension of time, that single sentence is not fairly read to establish cause, right? What it does is describes the complaint with 2 adjectives, 23 count, 45 page. And as I argued in my brief, Guitar Center is a $2 billion corporation that is responsible for approximately 30% of all musical instrument and musical equipment sales. They have sufficient resources to defend themselves and to defend themselves correctly.
Is that your determination or their determination?
That's what is publicly reported in business, reporting journals like Business Week and sources like Dun & Bradstreet.
So they get to tell that corporation whether they have enough resources to address your complaint?
No, Your Honor, that's my characterization
Okay,
from the size of the
that's my
company.
point, is that,
Okay. But they did engage Buckingham Doolittle at the beginning of this, a law firm with 63 attorneys who list their primary practice area as litigation. And there was
again,
absolutely...
do they have experience with your complaint before? Have they ever seen your 45-page complaint before?
No, Your Honor, but my
So
point...
it's a novel thing, I haven't seen this before, this is a new thing for them.
Yes, Your Honor, right? But it was at the point at which it was brand new, there were still 3 weeks left to answer.
And your presumption is they're gonna drop everything and handle your complaint on the spot?
No, Your Honor. My argument is that they have sufficient resources to bring in other attorneys if they need
And
more
how
time.
do you know that?
It is a conclusion based from those facts, Your Honor.
Okay.
Mr. Serra, can I direct your attention to the actual complaint that you
Yes.
filed here? And the answer, he says, you know, in response to my questions, how were you supposed to know this? That he, I'm referring to you, the attorney, I'm referring, actually, the client, Guitar Center Stores Incorporated, and Guitar Center. Guitar Center answered and said, you may have been dealing with Guitar Center, I don't know why this is so hard to say this today, Guitar Center Stores Incorporated. So, I'm just wondering, you know, when you said you didn't know until they filed a summary judgment, how do you dispute that?
Well, that's not exactly correct, Your Honor.
Okay, that's fine,
I
that's
found
fine.
out first in their answer, okay? But during the entire transaction, I was under the impression that I was dealing with Guitar Center, Inc., right? During the time that I spent preparing this 45-page detailed complaint, I took my Rule 11 pre-filing investigation obligation seriously, and I investigated. I went through the website from top to bottom. I went through all the documentation I had of the transactions, and in not one single place was any entity named Guitar Center Stores, Inc. mentioned.
I see that you attempted twice to purchase guitars that cost $1,099.
Yes,
Were you ever, was the money returned to you? Were you ever out the $1,099 with no product?
yes and no.
So did you ever get a guitar?
The way it works, Your Honor, with a credit card transaction of this type is when the sale was completed, my credit card issuer removes that amount of money from my credit limit and it is reserved for Guitar Center.
So they never actually debited your credit card that amount because you never got a guitar?
Well, again, Your Honor, I'm trying to answer your question, but I'm getting a little hung up on the terminology with debited.
Well,
Because
I
what
guess my
happened-
question is, you never got a guitar,
I never got a guitar. that's
and you were
correct.
never billed the $1,099.
It was charged to my card and never ended up on a credit card statement because Guitar Center allowed the transaction to quote-unquote fall off.
So you never were charged the $1,099?
I was charged it, but I was never required to actually pay the money to my credit card issuer because the charge was undone.
Okay, so you never pay, you're not out $1,099
No, I'm not, Your Honor.
either time,
No,
and you got no 2 guitars?
that is correct.
Okay.
And Mr. Serra, I regretfully need to inform you you've utilized the remainder of your time today. And thank you both very much for your presentations. Court will take the matter under advisement. We'll issue a written decision to be mailed to both sides. Also check our website and the Ohio Supreme Court website because we release our opinions on the Ohio Supreme Court website, which can be people.
Thank you.
Thank you. We're adjourned until Thursday.